I'm really excited and pleased to be able to introduce to you this very informative series of videos. It explains estate planning in great detail. My friend and the attorney who put together my own estate plan, Ed Gudeman, he's assembled the most complete explanation of the process, the do's and the don'ts of proper estate planning, and the purpose and the scope of each type of planning document included in the complete estate plan, again, that he's been doing for my listeners and for me and my wife. We've broken this webinar into several concise but thorough sections, which gives you the option of either binge watching all of them in one sitting or just one or two videos at a time as your schedule allows. You'll learn about wills, what they're for and how they're used. You'll learn about trusts and their great advantage, having your heirs avoid a long and expensive probate process. It also covers a number of other equally important documents that need to be part of any valid estate plan. I know once you've viewed this webinar, you'll be as comfortable going to Wills and Trusts Now to complete your estate plan as my wife and I were. Now, before we get to Ed, I want to leave you with just a couple of facts, okay? And I'm all about the facts. 55% of American adults do not have a will or another estate plan in place, right? And that's going to cause a lot of unnecessary pain to your heirs and to your loved ones. And I'm so glad we have one now. Another fact for you, 26% of women think that estate planning is too costly. I can tell you it's not, especially with the special pricing that I've worked out with Ed for you. Here's another fact, 13% of people believe that their spouse or their child automatically receive assets that they have. That's not true. And finally, the average time to probate a will in Michigan is 6 to 9 months and is likely going to cost your estate, or really your heirs, thousands and thousands of dollars in legal fees to complete. You know what you do? Avoid all of that, okay? Watch this seminar. Then I want you to call my friend and my partner, Ed Gudeman, lead attorney and founder of Wills and Trusts Now.
Hello, I'm Ed Gudeman of Gudeman Associates. I'm here today to talk about wills and trusts and other documentation that you may need to make sure that you have protected yourself and your family, including your spouse and children if you have them, and maybe even your grandchildren. Gudeman Associates has a program called Wills and Trusts Now. You've heard about us on Bob Dutko's show. And what we offer is a very comprehensive set of documents that includes wills, trusts, durable powers of attorney, healthcare powers of attorney, HIPAA release forms, and a variety of ancillary and supplementary documents that you may not have even heard of before, but that you probably need. So let's talk about estate planning today, and what we'll do is we'll go over a variety of documents and why you need them. But our main focus is to protect your assets and your family, and also to avoid probate. Probate, everybody says you got to avoid probate. Well, probate is the process by which a will is authenticated and verified and put into force, and by which a personal representative is appointed. So that personal representative has duties per statute as to how to handle your affairs. And the bottom line of probate is to transfer your property and to clean up your affairs. And that's why the state has statutes about this. In Michigan, it's called the Estates and Protected Individuals Code. And it's quite extensive, but it sets out the rules for if you die with a will or without a will. And it also deals with trusts and the powers of trustees and litigation and things like that. Hopefully, if you do things right, you won't have any litigation. So let's talk about how to avoid probate, because it can be very expensive. Typically, attorneys will charge, just to begin, an intestate or even a testate estate, and I'll explain what those are in a minute, $3,000 to $5,000. And that can go from there, and it can take 6 months, 9 months, maybe even more. So most people want to avoid that process because it's a very difficult process and an expensive one at a very difficult time, because somebody in your family, or including yourself, has passed away and created an intestate estate, meaning you died without a will, or a testate estate, meaning that you had a will that needs to be probated. But if you follow the rules that we have at Wills and Trusts Now, you don't have a probate estate. And so the will becomes just kind of a standby catch-all document. in case something has not been transferred over to the trustees of the trust that you will create. And by the way, you're the trustees of that trust, and I'll explain that a little bit more later on. So, in doing this, you should know that the focus is you and your property and making sure your affairs are in order, and that the courts never really have to be involved with them. Now, a lot of people don't understand why they need a will or a trust. We say you need a trust, and even if you don't have millions and millions of dollars worth of assets, you probably need a trust because it's the primary vehicle that is used to avoid probate and avoid those legal fees and other costs that you might incur or your family might incur if you don't have the right documentation. So statistically, people under 35, 95% of people who need a will or a trust don't have one. And for people over 55, it's about 50% of those people don't have wills or trusts. Mainly because people don't think about it, or they want to put it on hold because they just don't want to think about the fact that we all are mortal and we're all going to die at some point in time. But when you think about it, you are going to die at some point in time, and you really should take care of your affairs. My mother passed away about 10 years ago, and my father had died about 10 years prior to that. And she had a little bit of a sense of humor about her situation, and she left me a letter saying what to do on the inevitable death of your mom. And in that letter, she wrote where she had her trusts and her who was her accountant and who her attorney was and where her bank accounts were and things like that. And that made it very easy. And that's doing that type of thing is part of the program that we recommend, but it's not necessarily part of the documents that we do. But think about it. You know, when my mother died and my brother and I had to deal with that situation, she had taken care of everything for us. We had really very little to do. And it was a good thing that we didn't have to do that at a very sad and depressing and unfortunate time, and also a very stressful time. So these are things that we hope that you will do for your family, and we'll help you do it.